Welcome to the latest episode of Employment Talks, a Lydian podcast aimed at providing listeners practical insights into pressing employment law topics in Belgium. Hello, everyone, and welcome to the third episode of Employment Talks, a Lydian podcast aimed at providing listeners practical insights into pressing employment law topics in Belgium. Employment Talks is a Lydian podcast. Lydian is a full-service Belgian business law firm with a practical and personalized approach to practicing law. Through a fine blend of transactional law expertise and litigation skills, we deliver straight-to-the-point solutions that add true value. We think client-focused, we act fast, and we speak frankly in a language that you understand. From our offices in Brussels, Antwerp, and Hasselt, our mission is to find solutions through excellent legal insight and strong business instinct. That is how we exceed expectations, deliver consistent results, and forge long-term relationships with industry leaders. Counting 17 lawyers, Lydian's Employment, Pensions and Benefits team is the largest team you will find in any independent Belgian full-service law firm. We take pride in the size of our team because of the responsiveness it allows us to bring to our clients every day, but even more so, we are proud of the expertise that comes with it. All 17 lawyers, from associate to partner level, advise clients on general employment law topics, from the start until the end of the employment relationship, and everything in between, both on an individual and a collective level. Additionally, every lawyer has specific fields of interest, ranging from privacy, health and safety, pensions and benefits, to internal investigations and international employment. My name is Kato Aerts. I'm a partner in the Employment, Pensions and Benefits Department of Lydian, and I'm delighted to be your podcast host. Today, I'm meeting with Katrien Coenen, Senior Associate in our Employment, Pensions and Benefits practice for over 7 years and based in our office in Antwerp. Katrien is dedicated to helping businesses successfully navigate their workplace employment issues with a particular interest in working time. Welcome, Katrien. It's great to have you on this podcast.
Thank you, Kato. Great to be here.
This third episode of our podcast is dedicated to religious festivities and how companies should deal with these. On March 10th, approximately 800,000 people in Belgium started a month of fasting during Ramadan. During this time, they are not allowed to drink, eat, or smoke between dawn and dusk. On Tuesday, April 9th, Muslims will celebrate Sugar Feast, the end of Ramadan. Katrien, do employees in Belgium have the right to time off to celebrate Sugar Feast or other religious festivities?
Well, in Belgium, employees are entitled to 10 public holidays each year. The dates are fixed, and the majority of these public holidays are, of course, Catholic-inspired, such as Easter Monday or All Saints' Day on the 1st of November. So the question whether employees can ask for leave on religious holidays, such as the Feast of Sugar or Hanukkah for Jews, should be granted by employers depends on what is stipulated in Belgian law. And if we look at Belgian law, employers are not required to grant leave for these non-statutory holidays. The principle in Belgium is that you take leave by individual agreement between the employer and employee. As a consequence, taking leave on non-statutory holidays always depends on the employer's approval. However, the absence of an explicit right to take leave on non-statutory holidays does not prevent the employee from invoking other rights to obtain approval for their leave request. For instance, employees can refer to Article 20 of the Employment Contract Acts, which stipulates that an employer must provide sufficient time for employees to fulfill their duties of faith. This may also include providing leave for religious holidays. However, this right is not absolute, and it can be curtailed if the request of the employee would disrupt the company's operations or put an unreasonable burden on colleagues. So the willingness of employers to respond to questions around granting leave for religious festivities mainly comes down to organizational feasibility. If, for instance, your company only has one employee who requests time off for attending religious festivities such as a sugar feast, this will likely not be an issue. However, if 30% of your employees request the same holiday, this can lead to disruption, especially in manufacturing companies. In this event, it will be important to discuss solutions such as a rotation system, whereby 1 year out of 2, for instance, half of the applicants gets the holiday. And such system or other rules of priority for granting leave can be agreed upon in the company's work regulations.
Thank you. I think those are very valid recommendations. A question maybe some of our listeners have is, if there's no explicit right to take leave on non-statutory religious holidays, could a refusal not be considered discriminatory?
Yes, refusing leave on religious holidays can be considered as an act of indirect discrimination on grounds of religion or belief. In this event, the company will need to show that the difference in treatment was objectively justified. If an employer has been looking for alternatives, such as, for instance, colleagues who are willing to jump in or allowing employees to take half a day off, it will be easier for them to prove that there was no indirect discrimination or to show that this discrimination was objectively justified. If no alternatives are found and the leave would affect the company's operations, it can be argued that the difference in treatment was appropriate and necessary to achieve a legitimate aim, namely the proper functioning of the company. If, on the other hand, there were alternative solutions available, but the employer just decided not to allow leave on non-statutory holidays simply because the law does not explicitly require it, it can be established that the discrimination is not objectively justified.
And what about religious activities during the working hours? Should an employer give time off for prayers and provide a room where prayer can take place?
Well, as for religious holidays, there is no clearly enforceable right. Hence, the employees rely on the goodwill of the employer. An employer is legally obliged to grant reasonable accommodation to employees with a particular disability, but this does not count towards religious beliefs. In light of the prohibition of discrimination on grounds of religion or belief, and in particular the right of freedom of religion, which is not suspended during work hours, this discretionary and informal mode of operation seems problematic. However, the absence of an explicit reference to an obligation of reasonable accommodation does not entail that an employer can simply ban prayers during work hours. For example, an employer cannot prohibit its employees from praying during their break, as long as it's done discreetly and without disturbing other employees. At the same time, the employer is not obliged to set up a separate room where its employees can pray, and the time an employee spends praying will not be regarded as working time, since the employee is not at the disposal of the employer during this time. As to the question how to deal with requests from employees to facilitate prayers during work hours, the same reasoning can be followed as for granting leave for non-statutory holidays. If the company activities provide for sufficient flexibility and it's organizational feasible to allow it without disrupting other employees, then an employer should allow such requests. However, if after a factual assessment the employer concludes that it's impossible for the proper functioning of the company, for instance, because the nature of the work does not allow additional breaks or there is no separate room available outside of the common areas, then this indirect discrimination can be objectively justified. In contrast, if alternatives were possible, but the employee simply refused to offer them, then an employee may indeed argue that this is indirect discrimination, which is not allowed.
So, particularly in relation to Ramadan, for instance, can an employer approve a request for adjustments to the working hours, for instance, to start earlier when the employee is still energized, or allow more breaks during the fasting period?
Well, this will depend on the type of working time regime implemented in the company. It is possible to agree on different working hours and break periods, provided these are fixed in line with the rules set out in the company's work regulations. Indeed, in Belgium, as a general rule, it is forbidden to let employees perform work outside of the work schedules fixed in the work regulations. However, a possible solution is to let the employee work from home, because this rule does not apply when people work from home. So, insofar it is possible for the fasting employee to work from home, this could be a valid solution. Of course, in this case, applicable legislation on telework should be complied with. And in general terms, as fasting may also have an implication on the health and safety at work, it may be useful to also seek assistance from the prevention advisor on how to cope with possible effects on health and safety at work during Ramadan. For instance, for fasting employees who cannot work from home, it can be recommended to place them in teams with colleagues who are not fasting, and that way you avoid dangerous situations or mistakes when the fasting employees would be less alert.
Thank you so much, Katrien. It was a pleasure to host you on our podcast. Like the Beastie Boys sang in 1986, you gotta fight for your right to party. Many thanks for taking the time to record this episode of Employment Talks with me. I enjoyed it a lot, and I hope you did too.
I did, Kato. Thank you for having me.
The last words go out to everyone who tuned in for this episode of Employment Talks. I hope the content of this episode was as entertaining and interesting for you as it was for me. If you have any questions in relation to the topic we brought to you today, of course, feel free to reach out to Katrien or to myself. If you do not have our contact details yet, make sure to visit us on our website, lydian.be, or simply reach out through LinkedIn. This was Employment Talks, a Lydian podcast. If you liked this episode, please make sure to subscribe to this podcast wherever you listen to your podcasts, and feel free to leave a comment or share it with people you think may be interested too.
We look forward to hearing from you, and we would love to welcome you again in 2 weeks for our next episode.